Good afternoon, everybody, and thank you for joining us. I'm Christina Fox, the CEO of TechAlliance of Southwestern Ontario, a place for dreamers, doers, and world-changing ideas. We are committed to innovative companies who are launching, scaling, and competing in today's economic climate through our advisory services, our Accelerator, and certainly like experiences like these today with our partners and participants like all of you. The business landscape is rapidly changing both locally and globally, and I'm so pleased to be joined by my peer leaders, David Bilson and Brian Foster of RH Accelerator, and Dennis Ensing of Southwestern Ontario Angel Group, as well as their client companies and teams and our technology community. Feel free to give us a thumbs up. Brian, Dave, and Dennis, we're all in this together. Today is one of many webcasts in an ongoing series with industry leaders and experts to provide you with current information and resources that you need now to navigate through your options, weigh risks, and mitigate exposure to issues related to COVID-19. It is our hope through these partnerships and a webcast that we empower you to make informed decisions and demonstrate our collective commitment to supporting entrepreneurs on their terms with the guidance that they need most. We are so pleased to host an employment law assistance review in partnership with Siskinds so employers can navigate and understand their legal rights and obligations during COVID-19 pandemic, and so that you can make the best choices for your people and for your companies. Before we get started, let me share a few key points. Everyone is muted right now, but if you have any questions, please submit them through the Zoom Q&A feature located at the bottom of your screen. We are going to have our presentation and then we'll follow with the Q&A. This webinar will be recorded and will be available after the call. So now on to our presentation. I'm very pleased to introduce Siskinds labor and employment lawyers, Christopher Sinal and Liam Ledgerwood. Christopher exclusively represents employers in managing their relationships with employees, labor unions, and represent clients before the Human Rights Tribunal in occupational health and safety and in WSIB appeals. And Liam provides effective advocacy before courts and administrative tribunals for the labor and employment group at Siskinds. So please join me in welcoming Christopher and Liam. Now over to you guys.
Perfect. Thanks so much, Christina. So Liam and I are just going to take a few minutes today and run through some of the questions that we've faced most often in the last few weeks about COVID-19. As you heard, we're from Siskinds. Siskinds is a full-service firm based in London with offices in Toronto, Sarnia, in Quebec City as well. And Liam and I are from the management side labor and employment group. All we do is practice management side and advise employers on what's going on. And we've certainly seen certain trends in the questions that are coming in specifically around COVID-19. And so what we're going to do is hit the highlights right now this afternoon. And then obviously, if you have any questions, we'd love the opportunity to answer them. So first things first, is we're going to talk about health and safety, and I'll take a few minutes to talk about that. And then Liam will jump on and start talking about leaves of absence, which has come on a lot. So the primary question with health and safety is, what are the employer's obligations in a situation like this? In this, like most of the questions or most of the answers that you're going to hear, really we're in uncharted territory. And so most people are really trying to figure this out as they go. That includes the Ministry of Labor. And so when it comes to an employer's obligations in the situation, really we go to first principles, and that's 25(2)(h) of the Occupational Health and Safety Act. And that's, we're going to take every reasonable precaution in the circumstances for the protection of the worker. But of course, that begs the question, what is actually going to be reasonable in the circumstances? Because there's no set procedure for what we're going to have in a situation like this that's unprecedented. So whenever we get into, what would be the bar that we need to hit, what I usually tell clients is really, you don't care what I think. Instead, you want to know if you get called to task over, have you taken all reasonable steps? Answer that question is going to be the Labor Relations Board or an Occupational Health and Safety Inspector. And so the question becomes, what are they going to look at? And really, I have a sneaking suspicion they're going to be primarily driven by whatever the most recent and available guidance from public health authorities are going to be. So that should be what drives our decisions. I would look to the London Middlesex Health Unit, I'd look to Public Health Ontario, and I'd look to the federal equivalent. And the London Middlesex Health Unit in particular has done a very, very good job of centralizing guidances for various types of workplaces, everything from healthcare workplaces all the way through to essential operations that are still running, and given information on what types of health and safety procedures can you take to try and minimize contact exposure risks, to try and increase distancing in the workplace, and try and make sure that personal protective equipment is used efficiently and effectively. The next slide, if we can skip ahead a couple of slides, is a question that we get, which is it okay to ask employees whether they've been diagnosed with COVID? We got this question a lot early on. Generally, my guidance to my clients is that because if someone is diagnosed with COVID under the regimes that are in place right now, they're likely going to have that test done either at a testing center or through public health, and they'll be identified through public health. They're going to be directed to self-isolate immediately. So the brass tacks answer is it's unlikely that you're going to see an employee who's been diagnosed by COVID-19 and is still walking around. And chances are, if they are, and I don't mean to be glib, I'm just going to be blunt about this, they're likely violating at least one provincial law, if not multiple, and likely a federal law as well. And so it's unlikely that you would hit into the situation. And then, of course, if they are tested positive for COVID-19, then the public health authority is going to reach out. We're still in a stage where they're going to reach out and speak to their close contacts to advise them as well. The other thing that we're having a lot on the health and safety front is employees potentially refusing work due to their fear of infection. This is not only a health and safety problem, it is just a human resources problem. Keeping employees, particularly first responders or folks that are still in essential operations, motivated to continue performing their jobs is a task that many of my clients are running into. On the health and safety front, there is the potential for a work refusal, and that's someone citing the Occupational Health and Safety Act and saying, listen, this is unsafe work and I'm refusing to perform it. That is going to be very fact and context specific and dependent. The real question of whether in the workplace that they're in, is it going to be unsafe work? I suggest treating that on a case-by-case basis. Look at the individual factors with the employee. Are they in a high demographic risk group? Are they performing a task where they're likely to come into close contact? If the answer is no, then if proper social distancing procedures are in place in the workplace, if personal protective equipment is in place, and again, this is all very contextual depending on the workplace. The PPE that you're going to get on a line is very different than you're going to get in a long-term care home or a hospital. But if all of those boxes are checked, then likely the risk of exposure is relatively low. One of the stats that I've discussed with clients is right now, of the number of people who have been diagnosed with COVID-19 that were exposed in the workplace, excluding healthcare workers, is roughly 1%. And so as the stats are right now, the likelihood of being exposed and contracting in the workplace is relatively low. But that's because we're taking those procedures. So as long as those are in place, employers are likely in a fairly good position to say, listen, I don't think that the risk of infection is high, and so I'm not going to allow the work refusal to go forward. If the employee insists and says, listen, that's not good enough, then you will have to call the Ministry of Labor and have an inspector come in. We've been told by the ministry that they are prioritizing these. They are either by phone call adjudicating these requests, and at least anecdotally, we're hearing that they're generally finding that the procedures that are in place are sufficient to allow the worker to perform their job safely and effectively. The last thing I'll note on this before turning it over to Liam is that, of course, if you're in a workplace where exposure risks are part of the job and you're likely to experience those in the normal course of employment, or a work refusal is likely to endanger someone else's life, the Occupational Health and Safety Act prohibits you from engaging in a work refusal. Liam.
Thanks, Chris. And thanks to Christina and the whole, TechAlliance and the other organizations that have partnered today to let us have the opportunity to speak. I also wanted to kind of touch on the work refusal component that Chris mentioned, which is while some employees don't want to be in the workplace and sometimes the employers want them to be there, right? So kind of what Chris was describing was a work refusal scenario where the business wants the employee to attend. There are equally some of our clients who would be more than happy to have the employee not in the workplace for one of various reasons, right? Maybe there's issues having the financial resources to pay everyone's full wages. Maybe the employer is equally concerned about having everyone in the office. And even if there isn't a legitimate or comprehensive basis for the work refusal, the employer might nonetheless be okay with the reduced workforce. This is where some of the leaves of absence that are available to employers and employees come in. So until about 2 weeks ago, there was a mostly dormant provision in the Employment Standards Act, which was for declared emergencies. And it provided that an employee was entitled to a leave of absence in the event that there was a declared emergency. And Chris, chime in if I'm wrong, but as far as I am aware, this provision had almost never, if ever, been used or been triggered by any declared emergencies in the province of Ontario. So this was largely a
Liam, you're absolutely right. This was the leave that in presentations, when I was making fun of how many leaves there were, I would point at this one because, it was never going to get used.
Yeah, and it was almost laughable that the thought that there might be a declared emergency that would prevent people from coming to work. So it was the butt of employment lawyers' jokes for a long time. And yet here we were in a scenario where suddenly there's a global pandemic, which is shutting down businesses and shutting down the economy in many ways. And suddenly the government needed a leave of absence to apply that would protect employees who weren't able to perform their duties and responsibilities because of the pandemic. And this is when Doug Ford came out and specifically said to the good people of Ontario, look, you're not going to lose your job if you're put on a leave because of COVID-19. So that's exactly what the government did. They legislated a new and improved revised version of the declared emergency leave section of the ESA. Effectively, it is split into two different components. So you've sort of got a fork in the road, option A, option B, in terms of when employees are going to be entitled to a leave of absence. The first, as you'll see on your slide, we're generally calling declared emergency leave. So this is option one. And in option one, if an employee is unable to perform his or her duties and responsibilities because of an emergency declared under the Emergency Management and Civil Protection Act, and because of an order that applies to the employee under various legislation, then that employee is going to be entitled to a leave of absence. The leave of absence is tied to the duration of the order. So if the declared emergency lasts 2 weeks, the leave of absence will be 2 weeks. If the declared emergency lasts 6 months, God forbid, then the entitlement to that leave of absence will extend the full duration of the 6 months. So that's option one. It comes up in more context than just if the order applies to the employee. So there may be a scenario where the employee is required or needed to provide care and assistance to an immediate family member. The legislation goes into more detail about who is an immediate family member. But if the individual is needed to provide care and assistance, there will be entitlement to the leave of absence on that basis as well. Option number two, I'm calling infectious disease leave because that's the subheading in the new Employment Standards Act. And essentially in this option, the employee is going to be entitled to a leave of absence because of one or more of the following reasons related to a designated infectious disease. And no surprise, but the designated infectious disease right now is COVID-19. So the employee is under investigation or treatment related to the virus. So this will apply if a medical practitioner is currently supervising or in some way medically supervising essentially the employee for suspected COVID-19. The employee might be in quarantine or self-isolation. And again, this has to be ordered by some type of public health agency. So an employee deciding voluntarily to self-isolate won't necessarily entitle the employee to the leave, but it has to be because of directions issued either to the public or by one of these agencies, so a public health official, a doctor, or other qualified health practitioner, Telehealth Ontario, or a government of any level. The employee may also have been directed by the employer to to leave work in response to concerns that the employee may expose other individuals in the workplace to the designated infectious disease. So this is one of the only circumstances in these leaves. In fact, it is the only circumstance where it provides the employer, your business, with some opportunity to trigger entitlement to this leave without the employee requesting the leave. And Chris and I have had discussions about this, and Chris, by all means, jump in if you'd like, but we will see scenarios likely where employers are debating between layoffs and attempting to make use of a provision like this to recharacterize that as a leave of absence. And we have slides dedicated to that topic, so we're going to discuss that in more detail as well. Other potential triggers: the employee is providing care or support to an immediate family member. So this is the same subheading for entitlement that you have under the declared emergency sections, which is if a school or daycare has closed and the employee's children have to be at home, and this employee is required to provide care to those children, that employee is entitled to a leave of absence under the ESA. And it's going to be job protected and come with all the same benefits and entitlements that other leaves of absence come with. The final one, which is increasingly less and less likely to apply given the travel closures that we've had, is that the employee can't return to Ontario because of travel restrictions. This might apply to some of your businesses or organizations. Employees have been stranded in other countries. Airports are closed. Flights aren't really coming in and out. So if that applies, that employee is going to be deemed to be on this leave of absence. So what can you request in order to determine whether an employee is entitled to this leave? You can't ask for a doctor's note. We know that. In all fairness, not many employers probably would be asking for doctor's notes right now anyway, given that our public health system is so strained. But you are allowed to ask for evidence that is reasonable in the circumstances. So again, this is a gray moving target, and we're not really sure what that means, but we do know that you can't specifically request a medical note. And generally, the entitlement to the leave is the employee's. So an employee generally has to request it. But as I alluded to earlier, there might be some scenarios where it's the employer's conduct by keeping the employee away from work that might trigger the entitlement to the leave. And then what can the employee do? Again, we're going to discuss this, and Chris has something to say about the new Serb Benefits later in the presentation, but generally employees on this leave of absence will likely be entitled to the new Serb benefit that's been announced. We don't know that for a fact, but they should apply in any event if they're on this leave of absence. Chris, over to you about temporary layoffs.
Sure. So the emergency leave that Liam was talking about, generally is likely going to be available to employees whose workplace has shut down by virtue of that emergency order. So they're a non-essential business. They're not allowed to operate except on a work from home basis. And they can't do that. And so there's likely a good argument that they have the availability of that emergency leave. Also, as Liam said, there's going to be certain classes of employees, folks that are self-isolating, folks that have to look after kids, that are going to say, listen, I'm not able to work. For the rest, where there are employees who simply your business operations can no longer sustain them as it's going on right now, or even if you were ordered to close, or if for some reason you voluntarily shut down your operations before the emergency management order came out closing everything, the emergency leave wasn't really an option. And listen, if we're being honest about the whole thing, a lot of people didn't even know that the emergency leave existed anyway. So there's a whole bunch of people that will not be using that leave. And instead, what they likely have been using are layoffs. And layoffs is just an ideally short-term, temporary suspension of employment. In the States, they call it a furlough. Here, we call it a layoff. Here is the difficult part, is that even though there are rules in the Employment Standards Act that I'm going to talk briefly about how a layoff works, strictly speaking, unless you've got a collective agreement and you're unionized, or unless you've got an employment agreement that expressly gives you the right to lay off employees for periods of time, then technically, legally, a layoff is a constructive dismissal, because you're unilaterally altering a term of their employment. You're saying, guess what? You have to go home. I can't pay you any wages. The employee does generally have the ability to turn around and say, actually, you're firing me, you're not allowed to do that. That can be a complicated process. We have started to see some constructive dismissal letters come in, some demand letters from employers. The response to that, that we are likely to argue, is that even if there's not an express term in your employment agreement that we can lay you off, guess what? There's an implied term that practically has to be read into all employment agreements, that in circumstances like this, where there's been just an immediate and intense contraction over the span of 2 weeks, that we have the ability to put you on that furlough or that layoff. Similarly, there are other legal arguments available to suggest that we should be able to do this and that it doesn't end your employment, because frankly, we think for the vast majority of employees, they're not going to want their employment to end. They may not like the layoff, but they probably like the idea of not coming back to that job even less. Best practice tends to be in a situation like this, give the employees written notice of layoff if you can, keep them in the loop, let them know what's happening, be open in your communication with them. Even if there's no written notice that's strictly speaking required, the more open you are with your employees and the more that they understand that you're just trying to do the best for them and your business, frankly, the less likely that litigation is going to come from that. If you do lay off people, there are rules in the Employment Standards Act for how long it can go on for. Generally, it's 13 weeks in any 20. Once you hit that threshold, the Employment Standards Act, whether we like it or not, will deem you terminated, will deem the employee terminated. If the employee is getting health benefits or supplemental insurance benefits through a sub-plan that you run to supplement EI, then that limit can be extended to 35 weeks in a given year. But still, we'll run into situations where, God forbid this is going on for a while, employees are running up against this deemed termination date and we want to get out of it. And so we'll be looking for potential options. We also need to be cognizant of the fact that, what counts as a layoff for the Employment Standards Act. The Employment Standards Act will deem an employee to be laid off. They'll just say you're laid off whether you're calling it that or not, if they earn less than 50% of their regular pay. And so later on, we talked a little bit about, could we potentially reduce people's hours or wages in order to try and offset business reductions? We have to be careful of potentially triggering the layoff provisions of the Employment Standards Act and then the constructive dismissal claims that can go along with that. Layoffs will entitle people to EI, generally speaking, just as, if they go off to, because they're self-isolating or what have you for COVID, they may be able to go for EI sickness benefits. And the reality is they'll likely also qualify for those Serb benefits as well. And we have a note here that says, our understanding right now from what we're being told by Service Canada and clients is that anyone that has a pending application for EI, so they're not already getting EI benefits, is automatically going to have their application streamed into the Serb process to help take the load off of EI. Similarly, what do we do about financial support for folks that have childcare responsibilities? Serb explicitly is going to apply to those folks, and we'll be able to help them out as well. So now, Leo and I can talk a little bit about, when are you going to use the leave versus the layoff? Liam, you want to start with this?
Yeah, I think that this is more of a tactical or strategic issue for employers. So we know we've got these different options, right? I just discussed the leave options that are available in the ESA, but they come with the downside that historically and traditionally, these are entitlements that need to be exercised by the employee, not the employer. On the flip side, Chris mentioned the option for layoffs and the concomitant risks that come along with laying off an employee, namely the risk of a constructive dismissal. So one thing that we've seen some employers do is instead of going with the proactive layoff option, you can extend essentially invitations to employees. Do any of you want to take advantage of this brand new shiny leave of absence that the government recently introduced, which is the declared emergency or infectious disease leave? If you would, let us know, and we would be happy to provide you with the opportunity to go on that leave. So what does that do? Well, it probably mitigates the constructive dismissal or layoff risk in some ways, But of course, the employee is now on a job protected employment standards leave of absence, which means benefit continuation. It means you can't terminate the employment during that leave of absence for reasons related to the leave, and a few other things. And Chris, we've also seen some employers call a layoff sort of different names in order to try to recharacterize it as well, right?
Yeah, I think at a high level, what I would say is if your operations, or if an employer's operations were shut down by virtue of the order, they're a non-essential business, I think is absolutely open to that employer to communicate to employees, listen, we can no longer operate. There is this leave available to you. I would suggest you take it. Here's how that's going to work. Let me know if you have any concerns. It's kind of like a passive aggressive way of making them take it, but I think in the circumstances, that's probably an okay way to do it. There will be circumstances where folks have already been laid off, and those employers, again, if they're non-essential, may want to reach out to those employees and say, while we had you on layoff, now that there is a declared emergency and we are prohibited by law from operating, you might want to take advantage of this leave. What that does for you is stop the layoff clock, and it stops that kind of deemed termination from happening, which might be something that's attractive to employees. Now, the further away from the emergency and the government, order, the dicier the reliance on the emergency leave gets. And so if this is a situation where you're an essential operation or you're a non-essential operation who can perfectly adequately carry on your business remotely, it will get dicier for the Ministry of Labor, I think, if they're called in to question this, whether it's a legitimate exercise of the emergency leave, and then you're likely stuck with a layoff, which is not the worst thing. That's traditionally what we would see here. But there is that potential opportunity that an employee could turn around and say, listen, I think this is a constructive dismissal. To be clear, the difference between the leave and the constructive dismissal from the employee's perspective should not be significant. They're still going to be able to get EI or Serb benefits. The characterization of why they're off shouldn't change that. Really, all the emergency leave does for the employee is it's job protected. So obviously they can't be fired because they took that leave. It's not something that you're likely to do anyway. If they get healthcare benefits, you're required to continue those for the course of the leave. Most employers that offer healthcare benefits are doing that anyway, because that's one of the things that gets you that 35-week deemed termination timeline under the ESA. And so there's not a whole lot of downside for employees for using that emergency leave.
The only thing I would add to that too is just because an employee's specific circumstances won't fit in to the emergency leave provisions of the ESA doesn't stop you from granting that employee at their request a voluntary leave of absence in any event. So if an employee comes forward and just says, look, I don't want to be at work, I'm scared, and that doesn't qualify as a legitimate work refusal, and it doesn't necessarily trigger entitlement to the job protected leave of the ESA, that doesn't mean that you have to lay them off and attract that risk of a constructive dismissal. I've seen some clients instead say, okay, well, I don't really want to lay you off right now, but what we're willing to do at your request is grant you a discretionary leave of absence, and it'll be unpaid. We'll file your ROE and you can apply for EI or Serb. And ultimately you punt that responsibility onto the federal agencies, which will determine entitlement in that course. So briefly on top of the layoff, what we're also seeing is some employers attempt to introduce salary or wage reductions in this time without mentioning the job sharing program or work sharing program with EI, but just a straight up across the board 10% or 20% or more wage reduction. So going back to what we talked about with constructive dismissals, arguably, I mean, the case law in Ontario is pretty clear that any change in compensation equivalent to around 10% or more is likely going to be held to be a constructive dismissal. Again, that is in the normal course. So, Chris and I have joked that all of the case law that has interpreted constructive dismissal happened when there wasn't COVID-19. So we have no case law that directly speaks to our current circumstances, which is both a global pandemic and a very difficult economic situation for a lot of employers and potentially a pending recession. So wage reductions, you have to be very careful about with how they're structured. Generally, you should be trying to get employee agreement, even if that agreement isn't binding or enforceable. It will at least be evidence that the employer can use to suggest that this isn't a constructive dismissal. And then there might be other factors that your business would want to consider as well, which is, are you going to make this a temporary wage reduction based on cash flow shortages, and then you're going to make them whole again later? Sorry, my lights just turned off because they're motion detected here. So while Chris is talking about the Workplace Safety Insurance Act, I'll go turn them on.
There you go. So I'm going to be very brief, just in the couple of minutes that we have left. When it comes to the Workplace Safety and Insurance Act, I have had questions. If a worker contracts COVID at work, is it going to be covered? Is it going to be compensable? The reality is it's going to be on a case-by-case basis. The WSIB has no policy on it. The Workplace Safety and Insurance Board didn't exist the last time anything like this happened. Neither did the Ministry of Labor. And so the WSIB has been clear they're going to do this case by case. If you're a first responder, frontline, working very, very closely in close proximity with people, getting exposed to high viral loads, there's a strong likelihood that this is going to be covered by WSIB as a workplace exposure, just like it was in SARS. However, if you're exposed in a workplace with adequate social distancing and it could have been contracted anywhere else, then the likelihood of it being a compensable WSIB claim is more limited. The last thing I want to touch on briefly are this new Serb and EI benefits that are out there. I'm not going to spend a lot of time on this. The new Canada Emergency Response Benefits, Serb or CERB, don't know which one. Really, who's going to be entitled to that? Anyone who stopped working due to COVID-19, that includes people that are laid off, folks that are sick or quarantined and have to care for someone that's sick or quarantined, parents who have to stay home with kids, and other people that meet those criteria affected by COVID, not EI eligible, they can all use CERB. You'll notice a lot of those would also qualify for that Government of Ontario emergency leave, that job protected leave. To be clear, they're two independent things. One's just why you don't have to go to work, and the other one is how you're going to be compensated by the federal government. The CERB is up to 4 months. You'll get $2,000 a month. The applications will go live April 6th, I think, on the CRA website. To be clear, there is no means test with CERB. CERB, as far as we know right now, doesn't care how much you made before. And so there are people who maybe will make more money on CERB than they were making in their day job. However, CERB is fully taxable. And so you are going to pay tax on all of that income. That's essentially how it's going to come out of the wash. When it comes to EI applications, our understanding is that most of those are going to be streamed into CERB. If you have an existing supplemental benefit plan that you want your employees to be able to use, we've been told by some clients that EI has told them on the ROE mark that they're going to be participating in a sub plan, and that will alert EI not to stream them into the CERB process. Other than that, we generally don't recommend putting things in the comments section because that just slows the EI processing time.
I'm also going to discuss briefly the support for businesses. So CERB is obviously support for employees, right, who are on leaves of absence, but the federal government and provincial government have also introduced several supports for the businesses. The primary one that has gotten a lot of press right now is the CEWS, we'll call it, which is the Canadian Emergency Wage Subsidy. So this was only announced, I believe, early last week, and we've been waiting anxiously for more and more details, and they're coming through drip by drip. Every day we get a new little juicy piece of information about exactly how this new wage subsidy is going to work. So yesterday, the feds released a backgrounder or a more comprehensive document setting out exactly how this is going to work. So what we know is that in order to be entitled to the wage subsidy of up to 75% of an employee's wages, your business has to have a decline in revenue for any of the entitlement month periods of about 30%, of 30% or more, sorry. So if your revenues fall, and it's month over month compared to the previous year. So the government has released a document online which sets out that for March 2020, If between the two dates set out by the government, your revenues have fallen more than 30% compared to March 2019, you're entitled to the wage subsidy for March of 2020. Of course, the issue with this, and Chris and I were discussing this earlier, is that means it will be difficult for your business to know in advance whether you will in fact be entitled to the wage subsidy, because you're paying your employees on the front end, and only at the end of the month will you know how your revenues compared to the previous year. So that's one of the challenges that we're seeing with the current setup, but it's still a very generous wage subsidy, which is going to provide your business with a subsidy back of up to 75% of an employee's wages on the first $58,700 per employee. We don't have a lot of details yet about the mechanics. However, the government did announce that it's going to be set through the CRA's My Business Account portal, and it's going to be a web-based application. So again, we don't anticipate that this is going to be very complicated to apply for. It should just be a matter of logging in and clicking the button essentially to apply for the CEWS wage subsidy. And then ultimately the issue is going to be entitlement. So it's a month by month. That's the important thing here. And each month it's going to be a new entitlement analysis to determine if your revenues have fallen enough in order for you to qualify. And we don't really know yet the mechanics of how this money will return to the business. So it isn't quite as clear as the 10% wage subsidy that was announced earlier. And by the way, that's still live. So yes, the 10% wage subsidy that Trudeau announced about a week and a half ago now is still going to exist side by side with the 75% wage subsidy. The difference is you don't need to have that decline in revenues of 30% in order to be entitled. You do need to be a small business, and that's all defined in the documentation. So we know that for the 75% wage subsidy, any business in Canada will qualify. There are some criteria, but for the 10% wage subsidy, it's a small business, and it is right off of the remittances that you're sending off of payroll. So again, there are documents currently online as to how you can calculate this yourself, and you can start doing that immediately if you qualify for the 10% wage subsidy. We just don't expect that you'll be able to use both. We don't have confirmation fully on that yet, but we expect that you won't be able to get both. And then there's some other supports that have been announced. We still are waiting on details, but we know that the federal government is going to be issuing loans and guaranteeing loans issued to employers from banks. So there's going to be interest loans of up to $40,000 to small businesses and not-for-profits, as long as they had a 2019 payroll between $50,000 and $1 million. So that's going to be a significant portion of employers in Ontario, and $40,000 for some businesses might not be much, but for others, it would be enough to cover short-term liquidity issues, which is exactly what the government is hoping to do here. And then the federal agencies are also going to be working with banks, RBC, CIBC, and all the major lenders in the country to guarantee much larger loans so that there's no risk for the banks, because we know that the banks are going to be less likely to be issuing business loans in this context. And finally, and very simply, the provincial government has announced that all businesses in Ontario are able to defer their premium payments until August 31st, 2020. So that's great WSIB relief for businesses who are, Schedule 1 employers in the Workplace Safety Act.
Perfect. So very quickly, because I want to get to questions, Liam, I'm just going to run through these. Listen, it boils down to this. If you hear a lawyer on TV or you read something in the newspaper that says, here's absolutely what's going to happen, that person is lying because they have absolutely no idea. We've never faced anything like this in our legal system. Just a lot of the rules that we have in place weren't designed and haven't evolved to accommodate something like this. So even though when we run into things like layoffs, and the fact that everyone is on a little bit of dicey ground, unless you have that explicit language in your agreement. Is it legally dicey? Yes. But do the surrounding circumstances mean that you shouldn't do it? Listen, you should be taking care of your people, making the decisions that you think are right to protect the health and safety of your employees, and also to protect your business and make sure that they have a job that they can come back to. I think if you're making those decisions and you have a logical basis for them, and you're communicating that openly with your employees, then while you can take steps to mitigate rather the legal risk, it's going to be there. Instead, the risk that you look at mitigating is the litigation risk, the likelihood that those employees are going to come around and sue you at the end of the day. And if they trust you, if they believe that you have their back, and they understand why you're doing what you're doing, even if they don't totally agree with it, if you're showing that compassion and treating them with dignity, the likelihood of litigation is reduced. And that really is what we need to do at the end of the day.
Well, thanks so much, you guys, and thank you for sharing. Your presentation really rounds out the legal aspects of health and safety. We covered leaves and layoffs, the new Canada Emergency Response Benefit, and really all the supports that there are for business. But I think what we can do now is just move over to some of the Q&A that are coming in right now. So we have some questions that we'll start with. And the first one is, when you were talking about the declared emergency leave, someone was asking, is this federal or only in Ontario?
So right now, the amendments to the ESA, that's Ontario legislation. So it's going to be for Ontario regulated employers. If, if anyone in attendance at this webinar today is a federally regulated employer, so you're regulated by the Canada Labour Code or equivalent, that leave won't apply. We don't look at the federal legislation quite as much because a much narrower portion of employers are federally regulated in general. And off the top of my head, I'm not sure what leaves of absence they've introduced to address.
They rammed through analogous leaves in the Canada Labour Code when they rammed through the Serb.
Perfect. So there are going to be federal equivalents, but the leave and all of the qualifying criteria that I mentioned are specific to Ontario legislation, which again will be 90 to 95% of employers in Ontario.
Okay, perfect. Now, if you have a layoff clause in an employee handbook, but not explicitly an employment contract signed by the employee, inclusive of a layoff clause, would this cover the person to be able to lay off the employee?
I'm remembering at least one case where that was an issue, and essentially what it came, the starting assumption was no, it's not enough. But really what it turns on is, do you have language within your employment agreement that says the contents of the employee handbook are part of the terms of your employment? And then if they are, did the employee know them? Was the employee aware of them? Anytime there's a policy that's within a handbook, one of the things that the courts or the Ministry of Labor, whoever's looking at it, is going to want to know is, did the employee really know that this was actually a term of their employment? If there's just a clause that says, yes, I agree to be bound by the employer's policies, and then there's a 400-page employee handbook, they're going to be less likely to allow that to stand. The other thing that the employee handbook issue raises that I didn't talk about is when I said implied terms, so things that aren't explicitly written down. If you have a long practice of layoffs, whether it's sort of shutdowns during holidays, whether it's other types of seasonal shutdowns, and you have that tradition of doing layoffs, even if there's nothing in your employment contract explicitly, you can certainly argue that there's an implied term that during business slowdowns or cessations, you are able to lay off employees. And so that can sometimes be available.
Okay, now if an employee goes on emergency leave and once we get all the clear return to business, we realize we must make payments, permanent reductions. Are we able to terminate any that are on this leave already? So
the test for whether or not you're allowed to terminate somebody on a leave of absence is generally a 1% factor test. Is the one factor in the reason that you're terminating a person because they requested to take the leave of absence, because they took the leave of absence, or because they were inquiring about it? So if an employee is on this emergency leave and there's a restructuring that eliminates that position for legitimate business reasons, and the reason that you're terminating the employment has nothing at all to do with the fact of that leave, then generally that isn't going to violate the ESA, or at least it shouldn't. So I think that probably answers that question, because as long as there are legitimate business reasons for a termination, and that the termination has nothing really to do just with the fact that the employee took that leave, in general, you shouldn't be offside the Employment Standards Act.
Yeah, to really quickly, Liam, you're absolutely right. You know, I can think of two scenarios. In scenario A, you're an essential employer, everyone's at work, and then one employee says, my child, I can't get them into daycare, even though some of them are open for frontline workers, and so I'm going to take this emergency leave and go back. And then all of a sudden, once everything calms down, you engage in some layoffs and you only lay off one employee, and it's that one employee that took the leave. The Ministry of Labor is really going to wonder if you were just annoyed that one person didn't come into work. On the other hand, if you're ordered to shut down by the government and everybody goes on emergency leave, and then when it comes back, you lay off 30 people when they get back, then you're in a super good position to say, no, the fact that they were on a leave had absolutely nothing to do with it.
Okay. And when you were discussing wage subsidies, what if revenues decline 25%? Is it an all or nothing test for the wage subsidy?
That's our understanding right now, is that that's a triggering criteria for entitlement to the wage subsidy. I agree that superficially, there doesn't seem to be a big reason why you would compensate one business 75% of their wages with no cap if they have a 31% decrease in revenues, and a business with 29% decrease in revenues month over month gets nothing. But that appears to be the way that it's been presented to us. But again, we haven't seen any legislation or regulations yet come out. So it's possible that this will be addressed by the federal government. But as of right now, that is our understanding.
And this next one, I think you've covered this off, but what about companies that have come into existence only in late 2019? They started their company in September 2019 and now have seen a decline in revenue of about 60%.
Again, the way that it's been presented is that it's a calculation for year over year. Mm-hmm. However, I believe that I do remember seeing alternative calculation methods for businesses that don't have strong reference data. So this is another one of these questions where it's a moving target and we don't have a conclusive answer yet, but I expect that that will be addressed in the final version of what is put out, and that there will likely be a solution or a mechanism for employers who don't have that reference data yet.
Yeah, to Liam's point, CRA has said that they're going to come up with something to try and accommodate businesses that just weren't in existence a year ago. But I think they said they're actively discussing it with business partners. I can't stress enough the fact that everyone is making this up as they go, including the government. And so they had to ask for, I think, 3 or 4 extensions to tell us even these details. What will likely give us a lot more information is when the legislation actually gets tabled, probably within the next couple of days.
Wonderful. And then when you're talking about year over year, is the wage subsidy for revenue invoiced or revenue received over year over year?
My understanding, based on the document, the background are given to us, is that it's revenue as defined in the business's accounting documents. Mm-hmm. So this is going to be based on the company's financial statements and how they calculate revenue. So it may depend on how your business calculates and defines revenue for its financial statements.
Okay. Now the next question that come in is, we're a declared essential service, a charity not-for-profit, and we have an employee that is scared to come back to work, but we only have 20% work that can be done remotely. But that work would not be considered essential. It's more a make work. Does this employee go on emergency leave or layoff, or is it the EI job share alternative?
I think the difficulty here is that if you're an essential service that is allowed to be conducting operations right now, and the employee's not, let's say, engaging in a work refusal, this is an HR question. This is I think we can all understand people that are scared, apprehensive, and nervous about coming into work and just being outside of the house. But there are certainly situations where if there's work to be done, you can have that conversation with the person and say, listen, we can try and I hate to use the word accommodate just because it's loaded and it's suggested there's a human rights aspect to this, and I don't necessarily think there is. But have that conversation, because the reality is, as Liam said earlier, you could have the person go on a voluntary leave if you can afford to not have that person working. But there is some risk that if they're on a voluntary leave of absence, they're going to disentitle themselves to EI and potentially even from Serb, because Serb has without wages, but it can't be because you quit your employment. It's all going to depend on what they mean by quit. So, it could be risky. And if you can't afford to not have that person working, then again, I leave this to each individual employer with how hard they want to push this. But I've had some clients that have had to say, you have to come into work.
Yeah,
Okay.
and to add, I just want to add to that quickly. It really depends on what you want to do as the employer, which I think is what Chris was referring to at the end, right? If you really want this person back and you need them to continue operations, there are tools available to you to try to either gently or strongly push them back to work. If you are comfortable with them not being there, then there are tools available to you like the leave of absence and others in order for you to find a way to get them out of the workplace and entitle them potentially to EI, depending on the way that you code their ROE and everything. So that is the gray area that lots of employers are struggling with. What do we do with employees who may not be entitled to be away from work, but nonetheless don't want to be at work?
Okay. Now, if an employee challenges a layoff or reduction in pay as constructive dismissal, what is the employer's accountability for termination in terms of how many weeks per year of pay, service pay is required, especially for a small business that's under $1 million in revenue annually? And the second part to that is, would it be our choice or the employees?
So very briefly, how much notice or pay in lieu of notice you owe an employee if they're fired, whether constructive dismissal or a more traditional dismissal, is a multifactorial thing. It depends on how old the employee is, what the job market is like, how long they've been in the job. All of these factors are just to help a judge figure out how likely is it that they're going to go get a new job. The reality is right now, it could be really, really hard for people to get a new job. So even if they've only been there for, a month or two, it may be 6 months before they get another job. And even if you don't have evidence for that, whenever this gets litigated and it gets in front of a court again, when they open, chances are judges will think it will take a long time for people to get. So we might see very, very high notice periods. One of the unfortunate things is that the courts do not care about the size of the employer. They don't care about the means to pay the notice period. None of that matters to them. And so I'll tell you right now, if I got a demand letter from a lawyer representing an employee that was laid off, I'm going to be writing back and saying, I'm not paying you anything right now. Are you kidding? The reason the person's on layoff is because I'm not liquid. The reality is we don't know how long the purported layoff's even going to be. And employees, if they're terminated, have an obligation to limit the amount of damages that they suffer. That means trying to find other sources of income. So they better be applying for EI. They better be applying for Serb. And if this results in, let's say, a month or 2 months, and you were going to recall that person, you issue them a recall notice to the same job, and they're obliged to take it. And so now all of a sudden your damages are capped at whatever the difference is between the $2,000 a month they were getting from Serb, what their normal salary was, unless you're paying the 75%. And then whenever you recall them. So the damages may actually be limited, which is why if I get a nasty demand letter at this point that says, pay me $100,000, I'm going to say that's not a thing that's going to happen, my friend.
Right. And just to be cognizant of time, we're just going to be wrapping up here. I think we have 2 more quick questions to take. Do employees have to be working from home in order to qualify for Serb, or can we put them on payroll with no work to perform?
Yeah, so Chris, chime in here, but I think in this case, the Serb only applies for employees who aren't earning an income. So if you are working from home and you are earning an income, you're not going to be entitled to the Serb. There has to be an interruption of earnings for at least the 14-day consecutive period in the 1-month period for which the application is issued. So if you're working from home, you won't be entitled to Serb. You're going to be earning your employment income from working from home, which is the good news.
Okay, and then for our last question, it says, how would a due notice work for employees when it comes to transitioning them from 100% to 75% of their wage, and how would that change if they are currently temporarily laid off?
Chris, do you want to
So in terms of the notice that you're going to give, if you're trying to stave off a potential constructive dismissal threat, it would actually be the same notice as if you were terminating their job. And so the brass tacks reality, you probably won't be able to give sufficient notice, depending on how long they've been. If they're a very short service employee, it might be a matter of weeks, not months, but still it may be difficult. I think at that point, what you're trying to limit is the litigation risk as opposed to the legal risk, is the likelihood that they are going to turn around and sue you. If it's a question of, calling them back from layoff, but calling them back at a lesser wage rate, I think, again, if you're communicating that this is what you're able to do, not necessarily what you want to do, and you might be doing that with government assistance, the wage subsidy program, and what have you. One, I would hope that would lower the likelihood of potential litigation, but also, even if the person wanted to sue you, they have an obligation to mitigate, so they should take that offer, and then that's going to limit your legal risk.
Okay. Well, you know what? Thank you so much for answering all of those questions. I think we've covered them all. I just think that with uncertain economic climates, we really need to make informed and calculated risk decisions. And to support you, TechAlliance is offering a virtual office hours in partnership with Siskinds. And that's coming up next week on April the 7th from 1 to 4 p.m. And Siskinds will be providing a 30-minute individual phone consultations, and these are complimentary. A link will be sent to you following this session, along with a recording and the PowerPoint presentation as well. And I just want to say thank you so much to Christopher and Liam and from Siskinds and everyone there, and our community partners, Dave and Brian at Roundhouse Accelerator and Dennis at Southwestern Ontario Angel Group, who made this experience possible. So just as we depart and go back to our families and our different way of living and doing business, I just want to say thank you to everyone. Be safe, be well, and thank you for joining us.